First, this is a continuation of the regular meeting of the Board of Trustees of the State Bar of California. Good morning, everyone. Thank you for joining us. We are, just a very quick recap of yesterday. We made it through almost all of our open session agenda. We have 5 remaining items that we will take in short order this morning, and then we will recess into closed session. We'll start with items 701 and 702 together, which are both finance and budgetary related. So if we could ask Ms. Montoya Chico and who else? Oh, damn, I almost had it. Can we have the roll call, please?
Broughton, not present. Buenaventura.
Present.
Chen, not present. Cisneros.
Here.
Duran.
Here.
Good. Here. Knoll, not present. Shelby. Present. Soel.
Present.
Stallings.
Present.
Tony.
Present.
Trejo.
Present.
You have a quorum.
Thank you, Madam Secretary. Okay, now we will take up items 701 and 702.
Sorry. Good morning, everyone. I'm going to share my screen on item 701, so please let me know once you see it, please.
It's up.
Yep. Okay, so item 701 is the results of Q1 2023 financial statements. So I have a couple slides to go through. First, I'll start with our revenue results for the quarter, and then I'll follow with the expense results for the quarter as well. Here we have our Q1 results. You see that operating revenues for the quarter were 180. I have the right slides up. 188 million, about $8 million under budget. Similarly to how explained yesterday in our Q4 results, a lot of that is really a result of the grants. So if you see here, these are all of our different grants, and really most of the variance is accounted for in the Equal Access and Grants Fund and Legal Services Trust Fund, which are all grants funds and all pass-through revenues at the end of the day. On the general fund, it is slightly above our revenue estimates. We had higher mandatory fees than we expected, and pass-through insurance commissions. Pass-through insurance commissions, we get that money from for commissions from third parties, and then we actually disperse those through. So they are also a portion of pass-through in the general fund. We normally get those in the same quarter and pass them through in the same quarter, but in this case, we got the funds late in Q1, and we were not able to disperse them until Q2. So that cost a little bit of higher revenues than we had budgeted. Equal Access, as you can see, it is below budget by about 7 million, a little bit over 7 million, and that's really just a delay in the grant revenue that we were expecting to receive. We received most of it, or a big chunk of it in Q2, which is when this variance will decrease. Legal Services Trust Fund, as you can see, is pretty significant. It's also almost $22 million under budget. And again, similarly to EAF, it's just sorry, I was looking at Grants Fund. I apologize. Legal Services Trust Fund is $18 million over budget, and that is just a result of just higher rates that we're getting, as well as higher account balances. This will actually be one of the amendments that I will speak on my next item. Otherwise, Admissions Fund is close to budget. It's just half a million dollars over, and it's just more applicants that took the bar exam in February. Other funds is also pretty on budget with 600,000 over. I wanted to highlight one item in here. So this other funds, we group them together. There's a few other funds: elimination of bias funds, justice gap funds, legislative activities fund, for example. We did get higher revenues in elimination of bias and justice gap funds. However, the legislative activities fund, which turned from opt-out to opt-in in 2023, significantly decreased revenues we were expecting. So I did wanted to highlight that. Moving on to our expense results. This is the results for the quarter. We were at almost $90 million of expenses, which is under by about $20 million from our budget. And again, that's, as you can see, mostly due to the grants fund. where their expenses were under budget by almost 22 million. The general fund, as you can see, is pretty close to budget. Just a minor variance, and that's just due to slightly lower service expenses in the general fund. Otherwise, grants fund, equal access fund, equal access fund is slightly higher. Again, a timing of the grant disbursements that the Office of Access and Inclusion ended up doing versus what they had initially anticipated. The grants fund, as you can see, is a significantly below budget by almost $22 million. And that included the timing of the Homeless 3 and Homeless 4 grants. They had anticipated dispersing all of the grants in Q1, but because of some of the funding that didn't all come through, we ended up dispersing it in Q2. Otherwise, admissions is also slightly below budget in terms of expenses. They just had a lower than expected exam cost, bar exam cost for February. And the client security fund is also having lower payouts than expected, which is the small difference here you can see in their expenses. And that is all I have for the Q1 financial statements. If anybody has any questions.
I do have a question, if I could, please.
Please go ahead.
Thank you so much for the presentation. I'm just curious. I know that you're presenting it like that so it's clear. It's not necessarily like a gap statement, right? So as I'm following the statements, is that operating revenue figure, is that like consolidated for the entire organization? Is that safe to assume?
Yeah, the operating revenues at the top I had are bar wide, and then all of the funds below is what makes up your total, is the breakout of your total operating revenues or your total operating expenses.
Right. But presumably the cost associated with that revenue should be a wash because it is effectively a fund, right, from an operating standpoint.
Yes, but so you're right. It should be. A lot of the variances, particularly in the grants fund, which makes up a big. If you look at the numbers bar wide, makes up a big chunk of the revenues and a big chunk of the expenses. It should be a wash, but the timing doesn't always align.
I totally understand. So it's just for clarification purposes. That way. So then forgive my ignorance, because when I see operating revenue of 100 or 188 and I see operating expenses of 99. I see roughly a surplus of $80 million.
So you also, one thing to remember is we get a lot of revenue in Q1, but the expenses are not. So for example, in the general fund, right, most of our mandatory fees, which is what funds the general fund, comes in Q1. But the expenses in the general fund we incur them throughout the year.
Do you have I'm sorry, I didn't mean to bother you.
No. I said, so you will see a discrepancy in the first, really in the up until the end of the year, where revenues or expenses are not matching exactly the amount of revenues in any given quarter.
So now that said, what would be really useful, I think, would be a statement of cash flow, if you've got one, because I think then I get a better understanding of what our financial picture is, because I get it, because right now this looks like a healthy company, a healthy organization to me, right?
Yeah.
And I've been noticing that as the presentations going on and on, a statement of cash flow to me would be extremely, extremely helpful. And I think I have seen a balance sheet, and I've been kind of goofing around with that. But if anyone could get that to me, I think that'd be really useful.
We do have an attachment of the balance sheet in this agenda item. The cash flow, though, we don't have it quarterly.
It's not difficult, I don't think, right? It's a function, right?
Yeah.
So I think that'd be useful.
Okay, I can work on it, but I don't have one prepared that I can share with you readily available.
It doesn't have. I mean, there's no real time. I can kind of figure it out. I'm just. I think it'd be good to know.
Okay, sure, I can work on it. Anything else? Any other questions?
Any other questions? Okay, presentation on 702, Ms. Montoya Chico, or?
No, this one has a resolution, so we should.
Okay.
Probably.
Well, we're going to take the votes together, I think.
Oh, we are?
Yep.
Okay, great.
Unless you need or prefer them to be separate.
No. We can move on to 702. So 702 is the proposed budget amendment. I don't have a presentation for this one, but all of the details are attached in your in the agenda item that's posted. I'll just highlight I'll just summarize what the proposed amendments are. The first one is in the Legislative Activities Fund. As I mentioned, this fund, the fees that support the fund, that funded the fund, were converted from opt-out to opt-in starting in 2023. So that significantly reduced our revenues. We were anticipating a reduction in revenues, so we reduced it in our adopted budget to about $500,000, but the actuals after the billing season came into only 42,000. So we want to make this amendment to reduce budget revenues to actuals. So we're proposing a reduction in revenues for the Legislative Activities Fund of about close to $458,000. The next two amendments are grants related amendments. The first one is on IOLTA accounts, which sits in the Legal Services Trust Fund. And as I mentioned, we've been getting significantly higher revenues than we budgeted because we're getting higher interest rates and the account balances are also higher than we expected. So we're proposing an amendment to increase Legal Services Trust Fund by $67 million, and that's just to true it up to actuals. And then the last amendment is in the grants fund, and that's in particular for Homeless Prevention 4 grant. The actual revenues will be slightly under budget, so we're proposing a small amendment there of to decrease revenues and expenses. It's a pass-through rate. It's in revenues and out expenses by about $500,000. So in attachment A is the details of what I just spoke, and in attachment B is our updated reserve fund balances after these amendments. And just as a reminder, any grants funds are excluded from our target reserve policy. So the only one that is really subject to the target policy is the Legislative Activities Fund. And those are all the amendments.
Thank you, Ms. Montoya Chico. Any questions or discussion? I think I see Mr. Tony.
Thank you, Chair Duran. When it's time to entertain a motion, I would request being called upon to make the motion.
Okay, that sounds to me like you may want to add something to a motion, in which case I'd encourage you to make it now so we can discuss it.
It's simply, I move that the board approve the Q1 2023 financial report.
Okay, I stand corrected. You only made it sound nice and concise. I know we have a resolution attached to 701, so we'll ask to put that up on the screen. The budget adjustments that Ms. Montoya Chico just described, if they are acceptable to the board. Mr. Tony, would you include in your motion the approval of those budgetary adjustments as well?
I'm prepared to make a separate motion.
Ah, okay. All right, so we will not split 701 and 702. This is item 701 on the table with a motion by Mr. Tony. Is there a second?
I'll second.
Thank you, Mr. Sowell. Can we have the roll call?
I'm sorry, can I get a quick point of clarification?
Certainly.
We're voting on just 701 here.
Correct. The resolution is to approve 701.
Thank you, okay.
Yep.
Making sure.
Please take the roll.
Broughton, absent. Buenaventura,
Aye.
Chen,
I'm going to abstain because I missed the discussion.
Cisneros,
Aye.
Good, Knoll. Trustee Knoll, I do see you are present. If you could just activate your camera and microphone if you'd like to cast the vote. Thank you.
I have advice on 702 in terms of recusing myself regarding the grant-related amendments. You've gone to 701 now. I'm not sure whether or not I have to do the same thing at 701.
Trustee Knoll, your recusal only extends to item 702, and the board is considering item 701 only.
Okay, thank you very much.
Of course.
I vote aye.
Shelby,
Aye.
Sowell,
Aye.
Stallings,
Aye.
Tony,
Aye.
Trejo,
Aye.
Duran.
Aye.
It's 10 ayes, 0 nays. Motion carries.
Thank you, Madam Secretary. Mr. Tony, a motion on 702, please.
I move that the board approves the budget amendments for the 2023 budget.
Is there a second on the motion?
I'll second.
Was that so well? I'm sorry, I heard but did not
Yeah.
see. Thank you. Motion by Tony, second by Soel. Can we have the roll, please?
Broughton, not present. Buenaventura.
Aye.
Chen. Cisneros.
Aye.
Good. Noel.
I recuse myself from the vote as to the grant-related amendments due to a financial interest, and I vote aye on the remainder of the item.
Shelby.
Aye.
Soel.
Aye.
Stallings.
Aye.
Tony.
Aye.
Trejo.
I need to recuse myself for the grant-related portion, but aye otherwise.
Duran.
Aye.
10 ayes, 0 nays, motion carries.
Thank you, Madam Secretary. Okay, thank you, Ms. Montoya Chico, if you're still there.
You're welcome.
And we're going to move on. Recall, folks, that we dealt with a lot on our agenda yesterday, so we are going to not skip, but the next item up for consideration is item 707, which is a request to recirculate for public comment proposed amendments to the California Rules of Court related to state bar court judges and nominations and appointments of state bar trustees. These are reference to rules 9.11 and 9.90. This item is being presented by General Counsel Aline Davtian and Staff Attorney Brady Dewar. Welcome, Brady.
You got it right. Good morning, everyone. My name is Brady Dewar. I'm an Assistant General Counsel in the Office of General Counsel. And my first item is item 707. This item follows a Supreme Court directive to propose amendments to California Rule of Court 9.11, which sets forth procedures for the Applicant Evaluation and Nomination Committee to review and advise the Supreme Court and other appointing authorities on appointments to the State Bar Court, and Rule 9.90, which sets forth procedures for the Trustee Nominating Committee to advise the court on its appointments to the Board of Trustees. These amendments would require the committees to consider conflicts of interest and potential conflicts of interest in their evaluations of candidates. Specifically, the court directed that the amendments require the committees to, quote, identify and assess each candidate's actual and potential conflicts of interest in order to, quote, better achieve the goal of selecting independent and unbiased candidates. And at a minimum, these amendments must require candidates to disclose financial and non-financial interests that might affect or be affected by the candidate's service in the State Bar office in question, to require the candidates to provide a list of attorneys whom the candidate would identify as creating a conflict in any future service with the State Bar, and to require the committees to review this information and evaluate whether it might disqualify a candidate or reduce a candidate's rating. This item requests approval to circulate for a 45-day public comment proposed amendments to the rules of court that essentially do precisely what the court instructs, including adopting the language used by the court in its directive to the State Bar. Just a few quick notes about this. The proposed amendments do elaborate on the language provided by the court in a couple of ways. Each rule provides basic guidance in how the committees should consider whether conflicts or potential conflicts should affect a candidate's rating, instructing the committees to consider whether financial or non-financial interests would impact the applicant's ability to perform the duties of a State Bar Court judge or trustee with disinterested skill and undivided loyalty to the State Bar, and whether the candidate's financial or non-financial interests would impact the State Bar Courts or Board of Trustees, respectively, appearance to the public as a body that conducts its work with disinterested skill and undivided loyalty. The rules also specify, the proposed rules also specify that information about conflicts need only be collected from applicants who are to be interviewed by the committees, not in the initial application itself. This distinction will reduce both staff burden and barriers to submitting an application in the first instance. I also note that we initially developed a list of the precise types of information to be collected and considered And we considered including that in the proposed amendments to the rules of court itself. But after consultation with the Chief Justice's staff, we determined that this level of detail should be left to procedures to be developed by the committees as provided for in the rule. The types of information that we anticipate to be collected pursuant to those procedures, still to be developed, are set forth at pages 4 to 5 of the agenda item. So in sum, these proposed amendments follow the court's directive and will require the committees to collect and consider conflicts of interest information in evaluating potential appointees to the State Bar Court and Board of Trustees. And we recommend that you approve circulating for a 45-day public comment period. And that ends my presentation. I'm open for questions.
Thank you, Mr. Dewar. Any questions?
I have a question.
Trustee Trejo, please.
I'm just curious as to what the financial impact of something like this is to the organization. Out of curiosity, and I'm struggling to get on my account here to log in. But do we know what that is?
This is something that we anticipate would be handled by existing staff. There will be some additional work, obviously, in collecting and gathering, evaluating this information. Attempted to ameliorate that by only requiring it to be collected once a smaller group of applicants is identified to be interviewed. So we don't anticipate new staff or anything like that being required.
Thank you.
Trustee Chen.
I have a question about the particular language that is proposed to be added to both the State Bar Court judges and the Board of Trustees positions. There's mention of either confidential disclosure or disclose on a confidential basis. It's not clear to me what that means. Who would it be confidential as to, and would it be subject to a Public Records Act request? I mean, what is that intended to mean?
That's a great question. It would be shared confidentially with the evaluating committees, but it would be protected from disclosure under the California Public Records Act.
Thank you for the question and the answer. Trustee Tony.
This is a committee that I serve on, and so I don't remember right now who the other board member is, but
last time the committee convened, I believe it was a former trustee, Sonia.
Oh, okay. That's why I couldn't remember. Okay, and I think this is a great idea. We did not. I just want to confirm that we did not look at potential conflicts of interest. That was not part of the evaluation process. It wasn't a question that we asked. And I think that's an excellent practice. So I just want to, as someone who's participated in the process, support it.
Thank you, Mr. Sowell.
I also agree that I think this is a really important sort of step forward, given what it is that we've been doing with the ad hoc committee, et cetera. My question, and I have no problem with sending this back out for 45-day comment, but my question is, given what we just went through with the Girardi situation, on the Board of Trustee part of this particular item, do we need to be more detailed into what non-financial interest might be?
Certainly. So one thing that's common we ask you all about is membership on non-compensated membership on boards. So instances where you might be a member of a professional association that might have opinions on things that come before the board, things of that nature.
To Mr. Sewell's point, you could simply cross-reference the board conflicts provisions, right, which are also the subject of item 708 on our agenda. And so I would imagine you could, to provide further specificity, is simply reference what, if you were to become a board member, what we would expect you to pay attention to in terms of conflicts.
Certainly, and one of the delineated items that we'd collect or would suggest that the procedures require a collection of would be essentially to have appointees fill out a Form 700, such as they would be required to fill out if they were appointed, so that we'd have the same financial interest that they would disclose while they're still appointees.
So, I'm sorry, given what trustee Chen just mentioned, and if the rest of the board agrees, should that change be made prior to the circulation so that the public has a full notice of that cross-reference? I mean, certainly it would be clarifying if folks are looking very closely at it, which is one of the intended purposes of the public comment period, right? The public notice.
Chair, if I may, so that are in the as outlined in the memorandum, that particular component with disclosures related that would be required under the Form 700s, also the 2201 questionnaire, affiliation with any boards that a potential candidate will be sitting on, and other information that is going to be developed as part of the procedures. That will be also available and submitted to the California Supreme Court. So if you would allow us to move forward with the proposed rules, that detail will be included in the procedures that are the implementing procedures for the committees.
Okay, I think that makes sense. Thank you for the clarification. Any other questions or comments, Mr. Tony?
My only other comment is I'd like to recommend the addition of one more question for public comment, and that is, don't worry about the exact wording, okay, but the concept is, what's your position on whether the Board of Trustees should recommend that the rules for, the conflict of interest evaluation for Supreme Court appointed, or, nominees, whatever, for the, for the Board of Trustees by the Supreme Court, that we recommend that the other appointing bodies consider adopting similar procedures. Do you get what I'm trying to say?
Yes.
We only have authority. Yeah.
May I ask a question, Trustee Tony?
Please.
Is your thought that we would be making a recommendation that those appointing entities engage in their own similar process, or that
Yes, that they engage in their own process of determining conflicts of interest? It's, remember, this is just the question for the public, right? And so just to ask that kind of question, because, what I'm projecting here is, the Supreme Court has asked us to do this for them, okay? We don't have the authority over appointing authorities, but we could make a recommendation and say, well, the Supreme Court is doing this, perhaps you should consider, and they'll either do it or not, but I think that there's some value to recommending consistency for all trustees, okay, for all of us, no matter who our appointing authority is. That's my main point. And I'll leave the wording up to you. I'm not trying to wordsmith nothing, but it's a concept.
Great. We can, I'm sure you've seen the public comment website. We'll add that in the description of, in your feedback, please consider offering feedback on that. And I think it was implicit in your question, Trustee Tony, but just so everyone else understands, for the State Bar Court judges, the committee actually does evaluate the candidates up for appointment by other appointing authorities, and that has to do with the Supreme Court does have more control over the State Bar Court writ large than over all trustees.
Okay. Anything else on that particular issue or generally on this agenda item? Seeing none, do we have a resolution? With the understanding, of course, that the discussion that was just had would be taken into consideration as staff implements the resolution. And I don't think there's any need to make any changes. Given that, is there a motion on the resolution as presented?
So moved.
Motion by Good.
Second.
Second by Noel. May I have the roll, please?
Broughton, not present. Buenaventura.
Aye.
Chen.
Aye.
Cisneros?
Aye.
Good?
Aye.
Noel?
Aye.
Shelby?
Aye.
Soel?
Aye.
Stallings?
Aye.
Tony?
Aye.
Trejo?
Aye.
Duran?
Aye.
11 ayes, 0 nays. The motion carries.
Thank you, Madam Secretary. I like that critical mass there. 11 is a nice sounding number. It'd be great when it's 13. Next is a request to approve and submit to the Supreme Court proposed changes to the Conflict of Interest Code for the Board of Trustees. This item is being presented by our General Counsel. And again, Mr. Dewar.
So if I may, Chair, just make introductory note and turn it over to Brady. The board may recall that earlier this year in January, we set forth, I would say, a list of various enhancements and reforms in the space of conflict of interest. And one of those was updating the Conflict of Interest Code that applies to Board of Trustees. We later received a directive from the California Supreme Court to expedite that. And so this item specifically addresses that issue. It focuses on the financial disclosures that are required under the Political Reform Act, and is one of the many other additional activities that the organization has undertaken to address conflicts in response to some of the information that was released earlier this year. Without further ado, let me turn that over to Brady to make a quick presentation to you.
Thank you, Elaine, and great introduction. I'll just jump right in. So first of all, Elaine touched on this, why I'm in the code now. In January of this year, we discussed and presented a plan to the Board of Trustees that identified enhancement of the board's conflict of interest code and set a September board meeting target for presenting that to you. In the interim, the Supreme Court directed the State Bar to expedite this work and requested that we submit a proposed amended code to the Chief Justice by August 1st, hence we're here this month. Why this is necessary in a larger sense is that the current code, which requires disclosure only after the board has made a decision that affects the trustee's financial interest, does not meet the Political Reform Act's requirement of Form 700 disclosure of all financial interests that, quote, may foreseeably be affected materially by trustees in their decision-making for the State Bar. So the proposed amended code that we recommend for submission to the Supreme Court adopts the model code, which is promulgated by the Fair Political Practices Commission. We recommend, following this model for 4 reasons. First, it ensures compliance with all applicable law. Second, it will facilitate easy updating through adoption of regular updates to the model code by the FPPC. Third, it will create consistency with between the treatment of the board and the treatment of employees and sub-entity members through the conflict of interest code of the designated employees of the State Bar of California. That code already follows the FPPC model code and has for years. And finally, it will allow easy use of FPPC resources, which include an array of informational materials. They're linked to in our agenda item and available online, as well as training resources and advice resources. Just jumping into a preview of how the proposed amended code will operate. It makes several types of financial interests potentially reportable. First, investments in real property. Investments valued at $2,000 or more in business entities or trusts located or doing business in California may be reportable. Exceptions include many diversified mutual funds. Interest in real property valued at $2,000 or more located in or within 2 miles of California will be reportable. Exceptions include personal residences not used for business or rental income. Sources of income are reportable. Generally reportable are sources of income of $500 or more in a reporting period. Certain loans and travel payments are also reportable, and exceptions include government income. Sources of gifts are reportable. Generally include sources of gifts totaling $50 or more in a reporting period, and that's subject to numerous exceptions, including gifts from close family members and reciprocal exchanges of gifts of similar value on birthdays and holidays. Business positions are also reportable. Generally, disclosure is required if a trustee is a director, officer, partner, trustee, or employee, or holds any position of management in a business entity even if that's non-compensated. As Aline noted, this code does not deal with non-financial conflicts of interest or appearances of conflict. Those are addressed currently through Business and Professions Code 6036. And they're not part of this code because they're not within the jurisdiction of the FPPC or the Political Reform Act, which focuses on financial interests only. But the prefatory language included in the proposed code does remind and make explicit that this code is in addition to the provisions for non-financial conflict and recusal that are in the Business and Professions Code. So disclosure is only required if the financial interest falls into one of three designated categories set forth in the amended code. Category 1 requires reporting of all reportable interests in real property located in or within 2 miles of California. So if you have real property that meets the $2,000 threshold and it's not your personal residence, that will be reportable. Category 2 requires reporting of investments, income, and business positions or sources of gifts with, from, or in persons or entities subject to the regulatory, permit, or licensing authority of the State Bar, or that have an application pending before the State Bar. This category, as written in the code, includes a non-exhaustive list of examples, and it largely covers the legal industry: California attorneys and law firms, law schools, law students, and so forth. I do note that in the category 2 before you in the agenda item, there is a typo in that California lawyer referral services is listed twice. We will correct that as a Scrivener's error before submitting it to the Chief Justice. Category 3 requires reporting of investments, income, and business positions, including sources of gifts, with, from, or in persons or entities located in or doing business in California that manufacture, provide, or sell in California goods or services of the types purchased or leased by the State Bar. And again, there, the actual category sets forth a list of non-exhaustive list of industries that are covered. This category operates as a catch-all that includes the wide assortment of industries that provide services and goods to a larger organization like the State Bar. However, industries that the State Bar does not do business with, like aerospace, biotechnology, are some examples. They're not included, nor are individuals who do not themselves sell such products or services. Thus, this category should reduce reporting burden by narrowing the types of financial interests that you will need to report, while still ensuring that all financial interests that may foreseeably be affected by board decisions are disclosed. The code also includes a number of prohibitions. First, disqualification. And this disqualification is similar to that already provided in 6036, Business and Professions Code 6036A. In that trustees must generally disqualify themselves from participation in decisions having a reasonably foreseeable material financial effect on the trustee, their spouse, their registered domestic partner, or their dependent children, or any of those financial interests defined above. The exception is that disqualification is only required for decisions affecting donors of gifts totaling $590 or more. So if you get $50 or more in a gift in a year, you need to report it, but the disqualification obligation only attaches to sources of gifts totaling $590 or more. Disqualification is also generally required for decisions relating to contracts between the State Bar and parties that the trustee or their spouse or dependent children have done business with in the previous year on terms not available to the general public. There is also provision for honoraria. Trustees may not accept honoraria for speeches, articles, or event attendance from a source that would be reportable on their Form 700. There is an exception for income earned in connection with customary services in a bona fide business, trade, or profession. So if your business generally requires you to make paid speeches, that's not prohibited. There is a prohibition for gifts. Trustees may not accept gifts totaling more than $590 in a calendar year from a source that would be reportable on their Form 700. This again is subject to numerous exceptions, the major ones including gifts from close family members and reciprocal exchanges of gifts of similar value on birthdays and holidays. Finally, there is a provision for loans. Trustees may not receive personal loans from any officer, employee, trustee, consultant, or contractor of the State Bar. And that's subject to exceptions, including for commercial loans and credit card transactions, so long as they're made in the lender's regular course of business and on terms available to the public. So the next steps, assuming that the board approves for submission to the court the proposed amended code, is it will be submitted to the Chief Justice for approval by August 1st. In anticipation of submitting to the Chief Justice, we have consulted with the Chief Justice's staff while developing the proposed code. And based on that consultation, we don't foresee any major issues with obtaining approval. The trustees will need to make disclosures under the new code in their annual Form 700s, which will be due under this code on April 1st. The trustees will be trained on Form 700 disclosures later this year or in early 2024 before that reporting is necessary. And the proposed resolution does direct staff to develop a plan for future training. We will update the Board of Trustees manual once an updated amended code is adopted, and the proposed resolution also formally directs staff to complete that update. The policy update will also include the requirement to review and update the code regularly, consistent with applicable FPPC regulations. And that concludes my formal presentation, and I'm open for questions.
Thank you, Mr. Dewar. Trustees, any questions for either Ms. Dewar or Ms. Doughty on this extensive body of work? Trustee Stallings and then Soel.
All right, thank you, Brady, for that presentation. My question is, are we going to roll this out to our various sub-entities at some point, or is there discussions about how to, I guess, have consistency?
So the sub-entities are subject to the, or 5 of the sub-entities, those that make decisions that can affect financial interests, like the Legal Services Trust Fund Commission, the Client Security Fund. I don't have them all on the top of my head, but they are already subject to reporting requirements under the Conflict of Interest Code for designated employees of the State Bar of California. That will come, as it does most years, because we have changing positions, up for update in November, and we will, be looking at all of the reporting categories for employees and sub-entity members to make sure that they remain appropriate.
Trustee Soel, please.
Have no problems with the item itself, but am curious about one provision, and that is in the real property section, where it indicates, if you have property located within California or within 2 miles of the California border. I don't. What's the significance of the 2 miles?
So that's part of the model code, and it's actually based on provisions in the Political Reform Act. I believe, like all this, the intent, and I didn't read the specific, legislative history, but the thought is we want reporting of things that could be affected by a government agency's decision, and conceivably, if we're doing something, near a border. It could affect, it might not respect the state line.
Okay, no, you can't do it. I was just gonna say that is sort of a standard terminology that we see in these code of conflict of interest code. And even if your jurisdiction, say, is a county or multiple areas, it still builds in that 2 mile radius to capture a reasonable, industry standard of what could be considered potentially impacted by your decision if your property is within that space. It's a buffer, I think, that they've created to provide some reasonableness. And is that what you were going to say, Chair?
Pretty much, yes.
Okay.
Trustee Chen.
So I'm in support of doing this and really appreciate all the hard work that has gone into it. I do want to flag a potential issue with one provision, that I think we have to think about whether it may disincentivize certain types of lawyers from applying to join the Board of Trustees. And it's something that appears on page 6 of the agenda item. it starts with a bullet point, but if you look at the paragraph directly below the bullet point item, the second sentence says, well, let's read the first sentence. In addition to reporting direct income as discussed above, there are certain instances in which trustees would be required to report individual sources of revenue received by their businesses or employers under disclosure categories 2 or 3 of the proposed amended code. For example, if a trustee owns more than 10% of a business, the trustee would generally need to report a source of income to that business if the source would be reportable and the trustee's pro rata share of the income is $10,000 or more. To me, this raises the issue of solo practitioners who have their own firm, people who have a very small firm, say with 1 or 2 other people. This potentially would require disclosure of a significant portion of their client list. And for certain types of lawyers, say a criminal defense lawyer, you would be disclosing a list of criminal defense clients potentially. And, you know, I know that we have been criticized as a board for having too many lawyers who are from big law firms. And we want to make sure that we have representation from solo practitioners and small firm practitioners. So I do have a concern that this particular provision may make it challenging for some lawyers to, who are solos to want to join.
And thank you, Trustee Chen. We actually considered when we looked at this code, one thought was to basically require what's known as statutory reporting, and certain high-level officials and in fact state bar executives are required to report all financial interests without any limitation as to industry or anything like that. We actually went with a category 2 and 3 model because, for instance, for a solo or small firm practitioner who's doing criminal defense, most individuals will not fall into a category 3 unless they're actually engaged in they own a business or they're a proprietor who is engaged in the type of business that does business with the state bar. So hopefully by including category 2 and 3, we're going to keep solo practitioner and small firm lawyers from having to report that type of client who's going to have nothing to do with this sort of who's not going to be doing business with the state bar.
Can I also supplement? There is a provision in the code that would allow some privileged information to be redacted, and there's a process that we also discussed with the representative of the California Supreme Court on how to handle those situations where the disclosure of the client name may be privileged or otherwise protected. So there, we did consider that as well, that some of the information may be sensitive.
Trustee Cisneros, please.
Thank you. As a public official who has been filling out Form 700s for over 20 years, I applaud this move, and I think it's, in fact, quite a bit overdue. This is the kind of public information that all public bodies need to collect and make public, and transparency is really at the bottom of how we can all understand that we're doing our job well and recognizing that there's no conflicts. Thanks.
Thank you, Trustee Cisneros. Any other questions or comments before I say something? So what I would just like to add to what Jose just said is, along with what we're sending to the court as directed, and I think as supported by this board as part of our sort of overall reform efforts. And in light of the comment made by Trustee Chen, I'm very hopeful that as we implement these new standards and rules, that some, and you talked about training in the presentation, Mr. Dewar, but certainly some affirmative outreach to explain to people the distinctions, because they are meaningful, right? That statutory filer versus category 2 or category 3 requirements for disclosure will make a difference in whether somebody chooses to put themselves up for consideration. And so, to the extent that that can be done in a very concise, easy to understand, user-friendly way, for lack of a better word, I would encourage that we do that. Okay, Trustee Tony.
Thank you. I support adoption of this proposal. that's focused on financial conflicts of interest. I would like us in September to put on the agenda a discussion of non-financial conflicts of interest, perceptions of conflicts of interest. I just really want to make it clear that this is narrow, a narrow view of conflicts of interest, and conflicts of interest goes way beyond financial. So that's one. But I support this, but it's not sufficient. Certainly not with our history as an institution. And I also would like to make sure that the Board of Trustee conflicts of interest training not continue to be that watch a video, individual watch a video. No opportunity for dialogue, for questions, for, well, what if this? We need to make sure that that is done in person or by Zoom with all the trustees, with whoever's doing the training, and we can actually have a conversation of what it really means. I think that's important. That is the only way to develop a common understanding as a body of each of us, not to do this, self-training, go on the website and answer, listen to somebody talk and then answer a quick quiz. I think that's absolutely insufficient.
Trustee Stallings.
Just want to address one thing that Trustee Tony brought up, and that is, after reviewing the training, I had questions, and I reached out to the Office of General Counsel, and they have always been, extremely happy and ready with information. And I understand Trustee Tony's desire to have a standardization, but would also just, if anybody has a question, to reach out to OGC, and have always found them to be quick with an answer and with very good information. So I just want to thank OGC for the work that you've done in this space.
Trustee Shelby, please.
I have actually brought up this issue before in the past, and with my, 25-year history as a lobbyist, annually we would do ethics and compliance training. And everyone would be, when I was in corporate, everyone would be required to do it at the same time. I think for that very reason, where you have different things that shift from year to year. And so I would absolutely endorse, in our conversation in September, expanding conflicts in light of some of the things that have transpired as it relates to Girardi. I do think it's more than financial, but I absolutely endorse the fact that we should be doing training, an ethics and compliance training of some sort annually as a dais, and then that way people can have a dialogue and a conversation. Thank you.
If I could briefly respond, we did have in our plan that was presented in January an enhanced conflict of interest training proposal. As the board is aware, we're updating the code. We have proposed changes to the current non-financial personal interest statute, and some additional activity may be underway. So the thought was that once these new rules and new concepts are implemented, that the training will focus on those particular and new applicable provisions, so that it's a meaningful one. And I believe there was input already about having those in person, and so we did hear you, and we do plan on having a discussion that is more, not an online module, but at least, in person, instructor-led, which also will have a fiscal impact, but we can talk about that at an appropriate time.
I'm sorry, before you go, Brandon, let me just check in with Trustee Tony. In light of what the GC has just said with respect to non-financial interests and conflicts, are you okay to wait until it comes to the board as a whole for that discussion, or do you still want to have it?
I'm fine.
Okay,
For
good.
as long as the commitment is there, I'm very flexible on the timing.
Okay, great. Trustee Stallings, please.
My comments related to that area, so I'm happy to speak about it further at a later time.
Okay, preview of things to come.
Yeah, no, I'm fine as well, but I would also just make note that the ad hoc committee has been dealing with the issues of conflict. Trustee Shelby, Trustee Chin, and I have been, under Eileen's guidance, have been working through this issue of conflicts as well. With the number of new board members that we have, I do think that the timing is very right for us to follow Mr. Tony's lead on this thing.
Just another example, folks, of the often unseen and not always talked about serious work that's going into all of these reform efforts. I mean, I'm sounding like a broken record, but I really do want to say how much I appreciate the ad hoc committee's work, the GC's office's work, and this board's collective commitment to these important changes. These are not pro forma. I mean, these are real things born of real necessity. And so I'm hoping that our stakeholders recognize that and will continue to assist us as we're asking the Supreme Court to do here. Any other comments before we ask for a motion on the resolution? Okay, can I see the resolution, please? Trustee Cisneros makes the motion. Looks like Trustee Good's about to second.
Second.
Thank you. Can we have a roll call, please?
Broughton, not present. Buenaventura.
Aye.
Chen.
Aye.
Cisneros.
Aye.
Good.
Aye.
Knoll.
Aye.
Shelby.
Aye.
Soel.
Aye.
Stallings.
Aye.
Tony.
Aye.
Trejo.
Aye.
Duran.
Aye.
11 ayes, 0 nays. The motion carries.
Thank you, Madam Secretary. Our last item on our open session for the day is the overview of the State Bar performance metrics presented by Chief Missions Officer Yun Chang, Program Director Lisa Chavez, and Program Analyst Lisette Garcia. Welcome all.
Thank you. Good morning. This is a last item for the open session, but I would like to share with you, in my biased opinion, this is one of the most important topics, because if we want proof to the public and to ourselves that the State Bar is becoming, is growing to be a healthier organization, more efficient and effective, then the work and the progress needs to happen at the division level and at the office level. And the establishing metrics and the tracking work and the progress through metrics is one of such efforts to make sure that work is happening at the staff level. So Lisa and Lisette will walk you through the details and the analysis of 2021 metrics, 2022 and 2023. I would like to draw your special attention to 2023 metrics, which is attached to this board agenda item. We would, this presentation will be quick. We would like to have your feedback to the 2023 metrics we newly developed. Okay, Lisette.
Hello. In the next, I think Lisa will be sharing her screen, and then, okay. And then starting on slide 3. Okay, so in these next 2 slides, we'll provide an overview of the California State Auditor's evaluation of the State Bar metrics, and then also go into the 2022 State Bar metrics report. So the California State Auditor published a report in 2023 and reviewed 60 metrics from the 2021 State Bar metrics report. They measured success at the program and office level and concluded that in 2021, only 3 programs met all their metric targets during the entire year. And for 2022, we replicated the analysis and concluded that 7 programs and offices met all of the metric targets during the entire year. And then we also have a slide on the 2022 State Bar metrics. So that'll be the next one, please. Okay. And for this, in 2022, the State Bar tracked 60 metrics and reported the percent of metrics that met all targets during the entire year. And as you can see here, in 2021, 46% of metrics met all targets during the entire year. And in 2022, we see a slight improvement where 55% of metrics met all the targets during the entire year. And now turning it over to Lisa to review the 2023 State Bar metrics. Thank you.
Okay, thank you, Lisette. Hi, good morning, everyone. I'm Lisa Chavez. Before we talk about where we are moving forward, I want to just draw our attention to these two metrics report. Just a quick background, when I came to the State Bar 4 years ago, this became my project to take on. And this project has been a complete success because of Lisette Garcia, who just spoke. She's a program analyst, and she and I have worked very closely together. And when we met with the California State Auditor to ask all their questions with regards to the 21 metrics report, which they took a microscope to, I was so confident in having my discussions with them, answering all their questions about all the metrics, definitions, data, etc., how we handle the data. And it's because Lisette Garcia is just a very talented analyst who has incredible attention to detail and always goes the extra mile. So the reason why we have metrics is due to her diligence. So thank you, Lisette. So moving forward in our where we're going for 2023, I just want to share that we met with all our office leaders to really take a hard look at all the metrics that we've been tracking for the past few years. And we said, okay, we need to identify a set of metrics for your office. Some will be carryover metrics, some will be new, and some will be updated. And we made those decisions based on asking what matters most for your office. And so that was the philosophy that we took, was that ultimately the State Bar should be measuring what matters. And so as a result, we narrowed the number of metrics for offices. Before, we used to try to capture as many metrics as possible, and now we focused on really those that are most impactful. And when we did that, we also referred to the strategic plan and accompanying operational plan. Okay, so as we mentioned, we have 2 sets of metrics for your review. The first is attachment A. These are 19 case processing metrics, and we propose reporting to the Board of Trustees sitting as the RAD committee twice a year. So twice a year, we will prepare a report on those 19 case processing metrics that are in attachment A. And in attachment B, you'll see 49 what we call operational metrics. These are all metrics that pertain to all functional areas of the bar. And here we will be preparing an annual report once a year for this board. And so this agenda item asks that you approve the reporting schedule that we propose here. But as we mentioned, we would like to hear your feedback or questions or comments about the metrics that are in attachment A and B. Thank you.
Thank you, all three. I will tell you, Ms. Sheng, that as you concluded your introductory statement, I think to a person here in the boardroom, everybody sort of nodded and smiled, and there were a few out loud agreements to your assessment. So I appreciate that, and certainly do appreciate the work that Ms. Garcia has done. Just to echo Ms. Chavez, this is important data and tells a story of this agency in a way that doesn't always get seen. And certainly we're happy to receive the information and share it. At this point, if there are any questions from the trustees, I will open the floor.
So looking at the categories, and thank you so much for all the work that has gone into this. I think this is great that we are updating our metrics and adding a number of new metrics. I would encourage us to think about what metrics we should apply to ourselves as a board. And given the prior discussion, I wonder whether we should do things like ensuring that every single board member fills out a Form 700 and submits it, that is in our records. That was an issue that was highlighted by Erin May's report, was missing Form 700s for board members. I would like us to track making sure 100% of board members get trained on conflicts, and renewal trainings are another thing we can track, but I think we should also hold ourselves accountable as a board.
Hear, hear. Any other comments or questions? Mr. Tony.
I very much support Trustee Chen's recommendation that we come up with our metrics for board members. I have a couple of extra additional metrics, but then I want to go back to comments on the proposal. I'd really like metrics around restoring public confidence, demonstrating accountability, to build trust with legislature, and maybe the additional metrics we can take up at a later meeting. I don't think we need to wordsmith everything right now, but so that's one. We can always add more metrics. So I do have a concern about a few of the current metrics. I want to start off by pointing out metrics that are strongly written, and that I think are, so you go to number 6, the external random auditor recommends less than 4.3% of cases for reopening. That's strong because it has a goal. The next one, the California Supreme Court will deny 99% of Walker petitions. Again, less than 2% of complaint review unit dispositions result in reopens for reasons other than new evidence. So the ones that are not as strong are 1, 2, and 3. Decrease the percentage of cases in backlog status. There's no goal associated with it. I'd suggest that means there's no metric here. If you look at 2 and 3, very similar. And so there's an inconsistency to these. And actually have a list that I think I would like to see numbers. 1, 2, 3, 9, 10, 13, and 17. Just need to have goals associated with them. We may have some of this already in like the dashboard and stuff like that, but if it's going to be on here, I would really like to see that reflected, so that these become consistent with each other. And that's what I would like to see. And here's what I'm wondering. I'm wondering how urgent it is to approve this today. And, if this, serves as a staff guideline, we're going to approve this, okay? But the staff can come back to us at the next meeting with some of those, specificity. I would feel a lot better at supporting it at that time. At this time, I'm not able to support this.
I just want to clarify here, today's agenda item is about approving the reporting schedule, which is annual reporting for operational metrics and the semi-annual reporting for case process metrics. But I'd like to address the concern that Trustee Tony, you have. We are aware that some of the metrics don't have targets, and it is intentional. If you recall yesterday's presentation by Chief Trial Counsel, some of the targets we have set, Matt has worked with OCTC together to set all those targets. They are mostly from SB 211 proposal, because we have done a lot of research last year to build those targets. We devoted a whole chapter in SB 211 proposal saying those targets are not achievable for now. And from yesterday's dashboard, I think Trustee Trejo already pointed out, for non-complex cases, at the investigation stage, we have about 50% gap there. Is that the current efficiency is 50% below the target set there. So for us, when we set metrics, we have this criteria, which is called SMART: specific, measurable, achievable, relevant, and time bound. And achievable, that's my observation. If I look at 2021 and 2022 metrics, some metrics, you can see some offices keep failing those metrics. I personally feel that's demoralizing, and that does not reflect the work, the effort. If we can, actually track progress, have this kind of upward trajectory. But again, I I'm so happy to hear that the board wants to invest energy to further modify and polish those metrics. I think we can definitely do that probably in a smaller meeting, and we can come back in September to present those metrics, including maybe the board related metrics.
I just wanted to add, thank you, Ewing. Some of these, Mark, as I think we've discussed, where it's a new metric where we have not previously been collecting the data or analyzing it, I don't think we're in a position yet to set a target. So for example, number 9, 2201 matter case disposition time. I think you referenced one of the state bar court ones. I'm sorry, don't remember the number. So that's one comment I have. The other is, I think it is a philosophical question, right? It's sort of a, for example, on the backlog, one, statutorily, we are supposed to have a backlog of 0. SB 211 proposes a backlog of 10%. I believe it's no more than 10% of cases are in backlog status. So one is, if we were going to adopt a target, is it 0, which is what our current statutory framework suggests? Is it 10%, which is what our SB 211 proposal suggests, but that proposal has not been adopted by the legislature? Neither of those can we meet, to Ewing's point. And even when you, the discipline liaisons, recently were working with the chief trial counsel, I think the targets you've come up with are sort of this hybrid. So I think there's a question, should we adopt a standard at all? 1A, if we know that we can't meet it. 2, if right now, with respect to the backlog, for example, case disposition times 1, 2, and 3, we have competing standards that are out there, SB 211 versus the current statutory framework. So I think the board should consider that. I think our view is that for now, we should be tracking these, and we know that we want the numbers to go down. I also do want to clarify, previously, other than the first time when these were originally developed, the board has not approved the metrics. So as Ewing pointed out, we are asking for board input and then board approval of the reporting schedule back to you. You guys may want to change that, but so am taking notes on like Trustee Chen's comments, new metrics we need to propose or add. But I wanted to clarify that right now this is not up for a board vote.
Before we get to you, Trustee Stallings had his hand up, and then Trustees Tony and Soel.
Yeah, I think to Mr. Tony's point, you know, I don't want to speak for, excuse me, Mr. Cardona, but I think part of the difficulty in capturing a metric in the context of a prosecutor's office is that you want to do justice for every single case. And sometimes each individual case is going to involve entities outside of your control, whether it's state bar court, whether it's defense asking for continuances. And so I think there's aspirational goals as far as moving cases along, but I think we should really avoid what happened in the past, which was having an unrealistic standard, and you know, line prosecutors are pressured to move cases forward, and then we have a rise in Walker petitions because the cases weren't handled appropriately. So I think in a prosecutor's office, there's always that tension of we need to make sure that these cases are moved, but we need to also do justice, and justice looks a little bit different in each individual case with each, with all of those shifting factors. So, George, I don't know if you want to add anything to this discussion at this point, or sorry to make you get up. I know.
So agree with that. And there's a couple of reasons. That's one reason why we don't have outcome based metrics. In other words, we don't want to set a metric, for example, 20% of cases charged, because obviously that can create the wrong incentives in terms of evaluating individual cases and making decisions as to whether to pursue them or not. In terms of targets, there's some sense in trying to align our metrics with our dashboards, or with the understanding, if we do that we're not going to be meeting those metrics anytime soon, and what we're going to be looking for is moving towards those. So if we're looking for something that's achievable, then these metrics, which are worded as decrease, give us some targets. We could put targets on the decrease, but all of this is stuff that we can certainly talk about and come up with some, if we wanted to firm them up in terms of numbers, or leave them as they are, or align them with what we've got in our dashboard. Again, I think that's a decision, and Leah, I think, has outlined it correctly, the considerations that go into that.
Okay, thank you for the question and the answer. I would suggest you may want to just hang out there, Mr. Cardona, in case we get back to you. So the order, as I see it now, is Tony, Sowell, Chen, and then Trejo.
I will wait until those who haven't spoken yet speak, and then I would like to be put at the bottom of the list.
Okay, I can do that. Mr. Sowell.
My question is as I was listening to this discussion, I was sort of thinking about this theme of sort of accountability and transparency and sort of, showing the public that we're making progress. I started thinking about our strategic plan. And I was just wondering if there's any when we change metrics and we do these types of updates. I know we only do our strategic plan every few years, but is there some interaction with this in our strategic plan that we should be updating?
Can I respond?
Go ahead,
please.
Okay. So we have strategic plan, 5-year plan. Then we have internal operational plan. So operational plan is that we operationalize projects, the strategic plan items to projects. And that's also related with division and office. So when we develop metrics, we actually copy paste those operational plan projects to offices to ask them to look at their strategic operational plan, which is directly related with the strategic plan. I know there are a lot of terms here, but there's a link here. So that's what I'm trying to communicate. There's a link between 5-year strategic plan. We don't mean to change, but because we spend a lot of efforts to establish those strategic goals. But there is annual operational plan that to make sure we make progress and the promises we made in the strategic plan. Then we have this metrics, and we update them, at different timelines. In dashboard, CTC dashboard, 2201 dashboard, and this upcoming soon, crew dashboard, complaint review unit dashboard. We update those metrics quarterly. In this organization-wide metric report, we update them annually. But for case processing, we think it's so important. We want to see, the progress, so we can provide we, meaning the State Bar and board, can provide feedback to look at the semi-annual metrics. So there are links among those things.
And Arnie, at this point, if you go to our website and look at the strategic plan, there's now links to the underlying operational plan. So that's what we've developed internally to help operationalize the strategic plan. What are we actually committing to doing? And that UWEANS group tracks with all the different offices of the State Bar. And we've reported to you once so far on our progress on those operational objectives, and then we'll be reporting to you again in September. And then, as she said, those operational plan objectives have informed the development of the metrics. So you can see the direct linkage there. And I think some of those in the new areas that Trustee Chen suggested, those also do align with the strategic plan ultimately. So I think it'll be very natural to build that in.
Thank you. Trustee Chen.
I just have a couple of additional suggestions to consider, both for OCTC and for 2201. And again, just talking about conflicts. I mean, one of the things that the May report highlighted was lack of diligence in ferreting out conflicts. And I know we've taken significant strides in putting in place policy directives, new policies and trainings, making sure that CTCs are folks at OCTC are aware of the conflicts policies, The 2201 program has a new policy directive and conflicts process. And so I'd like to see some metrics that go to, can we measure our folks getting trained up, are conflicts analyses being done for each case and documented, that sort of thing.
Noted.
I'm sorry, did someone want to respond? Just noted? Okay, great. I think it's Trejo now.
Thank you. So I just want to make a general comment on data collection. I think with the presentation, which has been very good, very thorough, gave me slight flashbacks of graduate school and setting up my own data sets and, how I went about collecting data myself. And so I remember one of the keys in creating a base data or a base metric was extensive literature review. And as I'm sitting here and talking to all these trustees, components of a literature review are coming together and giving me context as to why some of these metrics are starting out where they are, right? And I understand the importance of keeping morale high. I do, but I think that if we're wishing towards results with the data is going to get tainted, right? I think that we have to go in and just expect to see what we see, irrespective of what, and then we're here to make recommendations, changes, whatever, but I think the more we have a good understanding of what's going on or where we want to go, even as a base case, and this is kind of the point I was trying to make yesterday with, you can make alterations to your base case once you have the first set of data come in. And you say, oh, my lit review was actually incorrect. Our assumption, and it's okay to be wrong. I mean, that's the beauty of statistics, right? You're trying to get to the truth. And so, again, I think trying things and getting them wrong perhaps, especially when you're coming to getting the right data set is important. And I think that you're on the right track. It's just that if we're going to start venturing into those avenues, just understanding context is important too. It's not just the numbers, right? You can get focused too much on that and not understand why they start off low, and then we're eventually going to see progression based on some of the policy that we put in together. So I think that I just wanted to add that as a component to say that, and Dr. Shen, you'd know better than I would. You're an expert at this. I remember in data collection, don't be scared of what the base case tells you. We're trying to improve here. We're not trying to necessarily prove our literature review before we have the data.
Mm-hmm.
So that's just my comment.
I just want to quickly respond. I have been in the State Bar for only a year, but I would like to say this is an organization where the data and the decisions based on data or evidence is highly valued. At least that's my experience here. Not saying we are where we should be. I think so much work that needs to be done. Just back to metrics. That's when Lisa talked about their work with offices. Just give you one example. Public Trust Liaison, they have a new metric about customer satisfaction. We want to improve our image and reputation and serve the public better. So Public Trust Liaison office is set for that purpose. How do you assess that the office meets that goal? Then we need to start to design the customer satisfaction survey. Even just design that one instrument involves a lot of literature review, understanding their operation, having their input in what are the most important items they want to ask their customers. So that's what I'm saying. This is, we will need to make progress, but this is not a one-time session. I'm so glad that the board is interested in the details of the work, but every item, every metric we are updating or proposing the new metrics we propose, there is thoughtful work. Could be even more thoughtful, but at least that's a starting point. There is thoughtful work, including instrument design, data quality, looking at other organizations. Another example, then I'm gonna stop. The other example is SB 211 proposal. We did a lot of research, both Georgia and George's team and my team did a lot of research, looking at other states, looking at the consultant's opinion, looking at the data we collected through years to make those to establish those targets. So yeah, so we know there's a lot of work that needs to be done here.
Thank you, Dr. Shang. Trustee Shelby.
Can I just make an observation?
Please.
Because I'm listening to the conversation, and I wasn't going to weigh in. And I really appreciate all of the different viewpoints, speaking as a layman, right? As I often do. But at the end of the day, as it relates to any of this data, we have to be mindful of who our real audience is. And our audience is the legislature, right? As it relates to, they are the ones who influence what we get to operate. And so I think that's important from the standpoint of being able to address the things that they're the ones who set our fee bill, right? We get involved in that process and we get to influence and weigh in, but I just want to be mindful of that as we get into the data and talking about the data, that we just don't lose sight of who the audience is that we really need to be talking to.
I agree, that's an important point. If there's no other trustee, Mr. Tony, before you close it up, I do have something to add, and that is an observation as well. And I hearken back to my first days on the board, and indeed any activity with this organization besides being a licensee in 2018. And I came on the scene at the tail end of the major change, right? The split between the associational and the regulatory functions, and the beginning of what we're now calling the 5-year reform era, right? The first era of reform. And I remember noting to myself mainly that Ms. Wilson, who was the executive director at that time for her first stint, was bringing along her staff and indeed at that time the Board of Trustees with the notion of metrics and concepts. And I'm going to say it, I recall some chuckles in the room and maybe even an eye rolling or two when Ms. Wilson would use the phrase metrics, because folks just were not accustomed to it or comfortable with it as a way of looking at the work of an agency like ours. And I just want to acknowledge her seminal leadership in this important effort. And Ms. Shelby's left the room, but I think her point is well taken, which is there are audiences here who are paying attention to this stuff. And I believe, and I have seen that Ms. Wilson and her staff, as represented in the presentation, do also understand and recognize that. And to your point, Trustee, so well, how it all ties in to our strategic plan and the work that Mr. Cardona's staff does. It's all related, and it's all about the story of how we regulate, how we protect the public. And so just an observation on my part. Mr. Tony, it's your turn.
You know, I'm just going to review some numbers. So the backlog at the end of 2022 was 2,315. The backlog at the end of June was 3,027. Okay? It's an increase from 39% backlog to 45% backlog. Okay, those are the real numbers, okay? And those numbers look bad for all of us because we are held accountable for those numbers, every one of us. And so, you know, my desire and, you know, to have metrics that say a little bit more, I agree. We don't want to adopt metrics that are impossible given the resources we have. But what I would like to say is that I think it's important for us to say, you know what? We want to see that number of 3,027. We want to see that go down. And we want to see it go down by, say, 10%. That's what I'm trying to say, okay? I don't think it's sufficient to say, well, if the number goes down by 1, it's okay. I think we need to have something that says, you know, let's bring down that number so that at the end of the year, it shouldn't be any higher than 2,700. That would, you know, just be, you know, so that's what I'm looking for. And I don't see that in this. That's what I'm looking for, that type of clarity as to, we will never reduce the backlog if we don't establish goals for reducing the backlog, okay? And I know that reducing the backlog is an absolute priority of the organization. And even if you reduce it by 10% each year, just because of the way the math works, it takes you 12 to 15 years to get rid of the backlog. So I'm not suggesting that we have to do it in one fell swoop. But if we don't establish realistic goals, mathematically, we don't get there. That's my point.
So why don't we just commit, Ewing, I'm just going to respond because so we can kind of move on from this one. But I think we'll just commit to going through each of the metrics that does not have a numerical target. If it's a brand new element where we've never collected the data, we will not be in a position to establish a target. But for those where we have some data, we'll work with George as appropriate or his respective counterparts and create some reasonable targets. I think that's what we can commit to doing.
That's satisfactory to me. Thank you.
Any other comments or questions?
I did want to make one comment. The beginning of this, the focus of the presentation was to go over the state audit report. And Trustee Tony, this item really comes, stems from a conversation you and I had where you wanted more explanation of why the auditor indicated that we had such low compliance or achievement rates vis-a-vis our metrics. And in the agenda item that's posted, staff, I think, has done a nice job of explaining the way we count as success versus the way that the auditor oriented its analysis, which was focused at the office level, different from how we do it. But I do also want to note this. In that state audit report, the very same report where they noted that we were unable to meet our stated performance objectives writ large throughout the organization, and they tied our failure to meet our objectives to a lack of staffing. So that was tied and connected in that state audit report. Yet and still, in their ultimate recommendation about the fee increase that we needed, the $24 that you all are very familiar with, they did not address the vacancy rate, the forced vacancy rate that is in place today, which is the very same vacancy rate causing us to be unable to achieve our performance objectives. So they noticed the failure to meet the objectives, they attributed it to staffing issues, and yet did not recommend the funding we would need to address. So I just wanted to make that connection clear for the board as well. Thank you.
Okay, thanks everyone for I think a very engaging policy discussion. More to come on that, I'm sure. We do have a resolution for your consideration. This is to approve the timing, the schedule. Is there a motion on the resolution? I will make that motion as the chair. Is there a second?
Second.
Second by Cisneros. May I have the roll call, please? I'm sorry. Trustee Knoll, I got you. Thank you. Sorry about that.
That's all right.
Sorry. Broughton, not present. Buenaventura.
Aye.
Chen.
Aye.
Cisneros.
Aye.
Good.
Aye.
Knoll. Trustee Knoll, I do see you're present.
Aye.
Thank you.
Sorry.
It's okay. Shelby? Yep, Trustee Shelby stepped away. Soel?
Aye.
Stallings?
Aye.
Tony?
Aye.
Trejo?
Aye.
Duran?
Aye.
10 ayes, 0 nays, motion carries.
Thank you, Madam Secretary. Thank you, Madam Secretary. That takes us to the end of our open session items. Thank you, Lisa, Ewing, and Lisette. Hope you have a good weekend.
Thank you. Appreciate the discussion.
Thank you.
Okay, we've got the following items on our closed session agenda. Pursuant to Government Code Section 1126, subsection A1, 1126, subsection C2, 11126 C7, E2B1, 2 cases under that code, and Government Code Section 1126 E2C1, 1 case. The Board of Trustees will move into closed session to consider the items listed on the closed session agenda. At the conclusion of that discussion, we will return to open session to announce whether there is any reportable action. In the meantime, we stand adjourned.
Trustee Knoll, you should have received the closed session link, so you can leave this session and use the link I just sent for closed session.
All right, this is Brandon Stallings, Vice Chair of the Board of Trustees. We are out of closed session. There are no items to report. So we will adjourn the meeting of the Board of Trustees. We'll see you next time.